I never thought a piece of farm equipment sitting peacefully on my property would turn into a legal battle that would expose the darkest corners of suburban corruption. But here we are. My name is Zachary Xander, and I live in Pine Ridge, Vermont, about 20 miles outside Burlington. I bought my 4-acre property back in 2019, a beautiful piece of land with a modest 3-bedroom farmhouse that needed work, but had good bones. The previous owner, an elderly farmer named Gerald Thompson, had lived there since 1982. When I purchased the property, it came with everything Gerald had used over the years, including an outdoor wood boiler that sat about 50 feet behind the main house. The outdoor boiler was a beast of a thing, a central boiler classic edge model that heated both domestic water and the entire house through a hydronic system. It was efficient, cost-effective, and in Vermont winters where temperatures regularly drop below zero, it was practically a godsend. I spent my first winter learning how to operate it properly, cutting and splitting wood, maintaining the proper water levels, and keeping the fire going. By my second winter, I had the routine down to a science. Everything was fine until the spring of 2023, when Pine Ridge incorporated as an official township and immediately established a homeowners association. I should have seen the warning signs then, but I was naive. The HOA started small, with reasonable rules about keeping properties maintained and not letting trash pile up. Then they got ambitious. The woman who appointed herself as HOA president was named Patricia Pemberton, a 52-year-old real estate agent who had moved to Pine Ridge from Connecticut 3 years prior. She lived in one of the newer development homes, a cookie-cutter suburban palace that looked like every other house on her street. Patricia had that particular brand of entitlement that comes from someone who has never been told no in their entire life. Her blonde hair was always styled in that helmet-like bob that screams middle management, and she wore pastel cardigans like they were armor. The first letter arrived on a Tuesday morning in October 2023. I was heading out to split wood when I saw the certified mail notice on my door. I signed for it, figuring it was something routine, maybe property tax information or insurance documents. Instead, it was a formal notice from the Pine Ridge HOA demanding that I remove my outdoor wood boiler within 30 days or face daily fines of $200. I read the letter 3 times, certain I was misunderstanding something. The letter cited a new regulation, Section 12.4 of the Pine Ridge Community Standards, which prohibited outdoor burning appliances due to air quality concerns and aesthetic considerations. It claimed that my boiler was an eyesore and a nuisance that violated community standards. I called the number listed on the letterhead immediately. A chipper voice answered, "Pine Ridge HOA, this is Deborah speaking." "Hi, this is Zachary Xander. I just received a letter about my outdoor boiler and I think there's been some mistake." "One moment, please." There was a clicking of keys. "Mr. Xander, yes, I see your file here. What seems to be the problem?" "The letter says I need to remove my boiler, but it's been on this property since the 1980s. It was here long before the HOA even existed." "I understand your concern, Mr. Xander, but the new regulations apply to all properties within the Pine Ridge boundaries. You'll need to speak with Mrs. Pemberton if you want to file an appeal." "Then I'd like to file an appeal." "Of course. Mrs. Pemberton has office hours on Thursdays from 2 to 4 p.m. You'll need to make an appointment." I made the appointment for that Thursday, already feeling my blood pressure rising. I spent the next 2 days researching. I dug through my property records, the original deed, and every piece of documentation Gerald had left behind. What I found was promising. The outdoor boiler had been installed in 1987, with proper permits from the county. There were maintenance records, fuel receipts, and even photographs dating back decades. More importantly, I discovered that Vermont state law had specific provisions for grandfathered equipment. Any structure or appliance that was legally installed and maintained before new regulations could generally continue operating under the old rules, as long as it remained in compliance with the standards that existed when it was installed. Thursday afternoon, I drove to the HOA office, which was really just a converted storefront in a small strip mall. I brought a folder thick with documentation. Patricia Pemberton sat behind a desk that seemed too large for the small space, flanked by two other HOA board members, a thin man named Marcus Chen, and a plump woman named Susan Fletcher. "Mr. Xander, please sit," Patricia said, gesturing to a chair across from her desk. Her smile was cold and professional, the kind of smile that never reaches the eyes. "Thank you for seeing me," I said, sitting down and placing my folder on the desk. "I'm here about the notice regarding my outdoor boiler." "Yes, we've been receiving complaints about it." "Complaints? From who?" "That's confidential, Mr. Xander, but multiple residents have expressed concerns about smoke and the appearance of your property." "My property is 4 acres, and my nearest neighbor is half a mile away. Who exactly is being bothered by smoke?" Patricia's smile tightened. "Regardless of proximity, the HOA has standards that all residents must follow. Your outdoor boiler violates those standards." "Actually, it doesn't," I said, opening my folder. "The boiler was installed in 1987, long before any HOA existed. I have the original permits, installation records, and documentation showing continuous operation. Under Vermont state law, specifically Title 24, Section 4413, my boiler is grandfathered in." I slid copies of the documents across the desk. Patricia barely glanced at them. "Mr. Xander, state law doesn't supersede our community standards. When you purchased your property within HOA boundaries, you agreed to follow our rules." "Actually, I didn't. I bought my property in 2019 before the HOA was established. I never signed any HOA agreement." "The HOA boundaries were established through township incorporation. All properties within those boundaries fall under HOA jurisdiction." "That's not how it works," I said, feeling my frustration building. "You can't retroactively impose HOA restrictions on properties that predate the association. Especially not on grandfathered equipment." Marcus Chen leaned forward. "Mr. Xander, perhaps we can reach a compromise. If you were to install screening around the boiler or relocate it to a less visible area of your property." "The boiler weighs over a ton and is connected to my house through underground pipes. Relocating it would cost tens of thousands of dollars, and screening would interfere with proper ventilation. This is my primary heat source." Patricia folded her hands on her desk. "Then I suggest you explore alternative heating options. The decision stands. You have 26 days remaining to comply." I left the office feeling like I had been talking to a brick wall. These people had no interest in reason or compromise. They wanted compliance, period. Over the next week, I consulted with a real estate attorney named David Morrison in Burlington. David was in his 60s, with gray hair and sharp eyes that missed nothing. He reviewed all my documentation and listened to my account of the HOA meeting. "You're absolutely right about the grandfathering provision," David said, leaning back in his chair. "The problem is that HOAs can be incredibly stubborn about these things. They'll fight you every step of the way. What are my options? First, send them a formal cease and desist letter. I'll draft it, citing the specific statutes and case law. Make it clear that their demand is legally baseless. If they continue to pursue fines or other actions, we can file for injunctive relief in court. How much is this going to cost me? David smiled sympathetically. Less than removing and replacing your entire heating system. I'll be honest, Zachary, these HOA disputes can get expensive, but you have a strong case. If we go to court, there's a good chance they'll be ordered to pay your legal fees. Let's do it. David drafted a comprehensive cease and desist letter that cited Vermont statutes, case precedent from similar disputes, and documented evidence of my boiler's grandfathered status. The letter was 8 pages long and left no room for misinterpretation. We sent it via certified mail to Patricia Pemberton and all HOA board members for a week. I heard nothing. Then, with 10 days left before the HOA's original deadline, I received another letter. This one was even more aggressive. The HOA not only maintained their demand but increased the daily fine to $500. They also threatened to place a lien on my property if I didn't comply. They're not taking this seriously, David said when I showed him the letter. Fine. Let's file in court. We filed a complaint in Vermont Superior Court, seeking a declaratory judgment that my outdoor boiler was lawfully grandfathered, and requesting an injunction preventing the HOA from imposing fines or other penalties. We also requested attorney's fees and costs. The court scheduled a preliminary hearing for December 2023. In the meantime, the HOA's deadline came and went. True to their word, they began assessing daily fines. I ignored them. I wasn't going to pay a cent for something I had every legal right to operate. The harassment escalated. Patricia Pemberton started driving by my property regularly, taking photographs. She filed complaints with the county environmental office, claiming my boiler was producing excessive smoke. An inspector came out, tested the emissions, and found nothing wrong. The boiler was operating well within all environmental standards. Then, Patricia got creative. She filed a nuisance complaint with the local fire department, claiming my wood storage was a fire hazard. The fire marshal came out, walked around my property, and gave me a thumbs up. Everything was properly spaced and maintained. She's desperate, David said when I told him about the latest inspections. That's actually good for us. It shows a pattern of harassment. The preliminary hearing arrived on a cold December morning. The courthouse in Burlington was an old granite building with high ceilings and dark wood paneling. I met David in the lobby, and we proceeded to the courtroom together. Patricia Pemberton arrived with 2 lawyers, a fact that David noted with raised eyebrows. HOA must have a legal fund, he muttered. The judge was a stern woman in her 50s named Judge Rebecca Morrison. No relation to my attorney, apparently. She reviewed the filings while we all stood at our respective tables. This appears to be a relatively straightforward matter of statutory interpretation, Judge Morrison said. Mr. Xander, your position is that the outdoor boiler is grandfathered under state law. Yes, Your Honor, David said. The boiler was legally installed in 1987, decades before the HOA existed. My client purchased the property with the boiler already in place and has maintained it properly. Vermont law clearly protects such grandfathered equipment. Your Honor, one of the HOA's attorneys said, a slick-looking man in an expensive suit. The HOA's position is that community standards apply to all residents regardless of when their equipment was installed. Public health and safety concerns outweigh any claimed grandfather status. What specific public health and safety concerns? The judge asked. Air quality, fire risk, and aesthetic degradation of the community. Judge Morrison looked skeptical. Has there been any documentation of actual air quality problems, any fires, Any property value studies showing degradation? The HOA attorney hesitated. The concerns are based on reasonable projections and community complaints. So no actual documented problems. The potential for problems is sufficient grounds for regulation, Your Honor. The judge made some notes. I'm going to review the statutory framework and case law more thoroughly. In the meantime, I'm issuing a temporary restraining order preventing the HOA from assessing fines or taking any action against Mr. Xander regarding the outdoor boiler until this matter is resolved. We'll reconvene in 30 days for a full hearing. I felt a wave of relief. At least the immediate pressure was off. Walking out of the courthouse, David clapped me on the shoulder. That went well. The judge sees through their arguments. What happens in 30 days? We present our full case. I'll need you to gather some additional documentation. Can you get statements from your neighbors? Anyone who can testify that your boiler hasn't caused problems? I can try. I spent the next few weeks talking to my neighbors. Vermont is full of independent-minded people who don't take kindly to busybodies telling them what to do, and most of them were sympathetic. My closest neighbor, Tom Richardson, a dairy farmer who had lived in the area for 40 years, was happy to provide a written statement. Patricia Pemberton is trying to turn Pine Ridge into some kind of suburban nightmare, Tom said, shaking his head. This used to be farm country. Now we've got people complaining about the smell of manure and the sound of tractors. Your wood smoke, that's nothing. That's the smell of winter in Vermont. I also contacted Gerald Thompson's family. Gerald had passed away in 2020, but his daughter Linda still lived in the area. She provided photographs and documentation about her father's installation and use of the boiler over the decades. Dad loved that boiler, Linda said when I met her at a coffee shop in Burlington. It saved him thousands of dollars over the years. He'd be furious if he knew some HOA busybody was trying to make you get rid of it. The full hearing in January 2024 was more intense than the preliminary session. The HOA came prepared with their own experts, an environmental consultant who testified about the theoretical risks of wood smoke, and a real estate appraiser who claimed that outdoor boilers decreased property values. David Cross examined them both mercilessly. The environmental consultant admitted under questioning that he had never actually visited my property or tested my specific boiler. The real estate appraiser acknowledged that he had no data showing actual property value decreases in my area, and that his opinions were based on studies from completely different regions. We presented our evidence methodically. David walked the judge through the timeline, showing that the boiler predated the HOA by decades. He presented the state statutes on grandfathering, citing 3 previous Vermont court cases where similar equipment had been protected. He introduced statements from neighbors, environmental testing results, and fire safety inspections. I testified about my use of the boiler, the cost of alternative heating, and the harassment I had experienced from the HOA. Patricia Pemberton testified about community standards and her vision for Pine Ridge. I want Pine Ridge to be a place where families feel comfortable raising children, Patricia said from the witness stand, where properties are well maintained and attractive. Mr. Xander's outdoor boiler represents an outdated, potentially dangerous technology that has no place in a modern community. Mrs. Pemberton, David said during cross-examination, how many complaints about Mr. Xander's boiler did you actually receive? Multiple complaints. How many? 5, 10, 20. I don't have the exact number in front of me. Is it possible the number is 0? Patricia's face flushed. I received complaints. David produced a document. This is a Freedom of Information request response from your office. It shows no filed complaints about Mr. Xander's property prior to your notice demanding removal of the boiler. Would you like to revise your testimony? Patricia's mouth opened and closed. There may not have been formal written complaints, but I heard concerns verbally. From whom? I don't recall specifically. So you can't name a single person who actually complained about Mr. Xander's boiler. Community standards don't require specific complaints. We act proactively. Proactively or arbitrarily, Mrs. Pemberton. Objection, the HOA's attorney said. Sustained, Judge Morrison said, but she was looking at Patricia with an expression that suggested the damage was done. The hearing lasted 2 full days. At the end, Judge Morrison took the matter under advisement, promising a written decision within 2 weeks. Those 2 weeks felt like 2 months. I continued using my boiler, kept up with my wood supply, and tried not to obsess over every possible outcome. David was confident, but courtrooms were unpredictable. The decision arrived on a Friday afternoon in late January. David called me immediately. We won. Complete victory. I felt my knees go weak with relief. What did the judge say? I'm reading from the decision now. Judge Morrison ruled that your outdoor boiler is clearly grandfathered under Vermont law. She found that the HOA's regulations cannot be applied retroactively to lawfully installed equipment that predates the HOA's existence. She issued a permanent injunction preventing the HOA from taking any action against you regarding the boiler. And here's the best part, she awarded you full attorney's fees and costs. The HOA has to pay for everything. How much are we talking about? About $15,000 so far. They're going to be furious. David was right. 3 days after the decision was published, I received a nasty letter from Patricia Pemberton, personally signed, claiming that I had harmed the community and that the fight wasn't over. The letter had an unhinged quality to it, full of capital letters and underlined phrases. I showed it to David, who frowned. This is concerning. She's taking this very personally. Keep this letter. Document everything. If she continues to harass you, we may need to pursue additional legal action. I didn't have to wait long. 2 weeks later, I came home from work to find my wood pile scattered across my property. Someone had used a vehicle or machinery to push over my neatly stacked cords of wood, leaving them in a jumbled mess. It would take days to restack everything properly. I immediately called the police. A deputy from the Chittenden County Sheriff's Office came out to take a report. Deputy Walsh was a no-nonsense woman in her 30s who walked around my property, taking photographs and notes. Any idea who might have done this? She asked. I have suspicions, but no proof. Care to share those suspicions? I explained the situation with the HOA, the court case, and Patricia Pemberton's threatening letter. Deputy Walsh's expression darkened. That's vandalism at minimum, possibly criminal mischief. Do you have any security cameras? No, but I'm going to install some now. Good idea. I'll file this report and increase patrols in your area. If anything else happens, call us immediately. I spent the next weekend installing a comprehensive security camera system. 4 cameras covering different angles of my property, all feeding to a digital recorder with cloud backup. The whole setup cost me about $2,000, but after the wood pile incident, it felt necessary. The cameras proved their worth sooner than expected. On a Tuesday night in February, at 2:30 in the morning, motion sensors triggered and woke me up. I checked the camera feed on my phone and saw a vehicle with its headlights off pulling up to my property. A figure got out and approached my outdoor boiler carrying something. I dialed 911 while pulling on clothes. Someone is trespassing on my property right now. They're approaching my outdoor wood boiler. The dispatcher kept me on the line while I watched the camera feed. The figure was doing something near the boiler, but in the darkness and with the camera angle, I couldn't make out exactly what. They worked for about 3 minutes, then hurried back to their vehicle and drove off without lights. 2 sheriff's deputies arrived within 10 minutes. I showed them the camera footage. One of them peered at the screen. "Can you zoom in on the vehicle?" I could, but the image quality decreased significantly. Even zoomed in, we couldn't make out a license plate, but the vehicle appeared to be a light-colored SUV. What about the person? The figure was wearing dark clothes and a hood, face not visible. But there was something about the body's shape and movement that seemed feminine. The deputies went to check on the boiler with flashlights. I followed them outside. "Mr. Xander, you're going to want to see this," one of them called out. Near the boiler's air intake, someone had poured what looked and smelled like bleach. If I had loaded wood and fired up the boiler without noticing, the chlorine fumes could have damaged the system or created toxic smoke that might have entered my house through the heating system. "This is serious," the deputy said. "This is attempted property damage at minimum, potentially reckless endangerment. We need to take samples and file a full report." The deputies spent the next hour documenting everything, taking photographs and collecting samples of the bleach. They took a copy of my security footage. "Mr. Xander, given the history with your HOA president, we're going to want to talk to her. Does she drive a light-colored SUV?" "I don't know what she drives. We'll find out. In the meantime, keep your cameras running and don't hesitate to call if you see anything suspicious." I didn't sleep the rest of that night. I kept thinking about what could have happened if I hadn't been alerted, if I had just loaded wood and started the fire like normal. The bleach could have corroded components, the fumes could have been toxic, and at worst, it could have created a dangerous situation for me and my home. The next morning, David called me before I could call him. "Zachary, I just heard from the sheriff's office. They requested Patricia Pemberton's vehicle information. This is escalating fast. Someone tried to sabotage my boiler last night. I heard. This is beyond HOA harassment now. This is criminal. I've contacted the district attorney's office to make sure they are aware of the full context." 2 days later, Deputy Walsh returned to my property with another investigator. "Mr. Xander, we have some information to share with you. Patricia Pemberton drives a white Lexus SUV. We've interviewed her, and she claims she was home all Tuesday night. We've requested her phone records to check cell tower data. So you think it was her? We're investigating. The problem is, your footage shows someone in dark clothing and a hood, but we can't make a positive identification. However, we did find something interesting. Mrs. Pemberton purchased a large quantity of bleach from a hardware store on Tuesday afternoon, paid with her credit card. That's pretty damning. It's suspicious, but not conclusive. People buy bleach for legitimate reasons. However, combined with the ongoing dispute and her threatening letter, we have enough to keep investigating." Over the next week, the police investigation continued. They pulled security footage from the hardware store where Patricia had bought the bleach. They checked her phone records and found that her cell phone had pinged off a tower near my property around the time of the incident, even though she claimed to be home. Meanwhile, Patricia made a critical mistake. She filed yet another complaint with the HOA board, this time claiming that my security cameras were an invasion of privacy because they might capture images of people on the road near my property. It was a ridiculous complaint. Cameras on your own property pointing at your own property are completely legal, but it showed she was aware of the cameras and concerned about them. David saw the complaint and immediately recognized its significance. She's worried about the footage. This complaint was filed the day after the bleach incident. She knows the cameras caught something. The break in the case came from an unexpected source. Susan Fletcher, one of the HOA board members who had been at that first meeting, contacted my attorney. She wanted to meet confidentially. David and I met her at a neutral location, a diner halfway to Burlington. Susan was nervous, her hands shaking as she stirred her coffee. "I need to tell you something, but I'm afraid of retaliation," she said. "What kind of retaliation?" David asked. "Patricia has been acting increasingly erratic. After the court decision, she became obsessed with finding ways to punish Mr. Xander. She talked about it constantly at board meetings. She said, these are her exact words, that she would make sure you regretted defying the HOA. Did she ever mention doing anything specific?" I asked. Susan hesitated. "3 weeks ago, she said something about teaching you a lesson, about making the boiler more trouble than it was worth. I didn't think much of it at the time. I thought she just meant filing more complaints or something. But after I heard about the vandalism and the incident with the bleach, I started connecting dots. Would you be willing to make an official statement to the police?" David asked. "If I do, Patricia will make my life hell. She'll probably try to kick me off the board or worse." "Susan," I said, "someone tried to damage my property in a way that could have hurt me. If Patricia is willing to go that far against me, what happens to the next person who crosses her?" Susan closed her eyes, then nodded. "You're right. I'll make a statement." Susan's testimony was the piece the investigators needed. Combined with the physical evidence, the phone records, the purchase of bleach, and Patricia's documented hostility, they had enough for an arrest warrant. Patricia Pemberton was arrested on March 15, 2024, and charged with criminal mischief, attempted property damage, and reckless endangerment. The arrest happened at her home, early in the morning, and according to Deputy Walsh, Patricia maintained her innocence throughout, claiming it was all a conspiracy orchestrated by me. The local news picked up the story. The image of an HOA president arrested for allegedly sabotaging a homeowner's heating system was too good to ignore. A reporter from the Burlington Free Press contacted me for an interview. I was hesitant, but David encouraged it. Public awareness can be helpful. It shows this isn't just a personal dispute. It's about HOA overreach and abuse of power. The article ran with the headline, "HOA President Arrested After Homeowner Dispute Turns Criminal." It detailed the entire saga, from the initial demand that I remove my boiler, through the court case, to the alleged sabotage attempt. The reporter interviewed Tom Richardson and other neighbors, who painted a picture of Patricia as someone who had become increasingly authoritarian in her role. The story went viral locally, then started getting picked up by regional outlets. Within a week, I was getting calls from news stations as far away as Boston and New York. The narrative of an out-of-control HOA president arrested for retaliating against a homeowner struck a nerve with people who had their own HOA horror stories. Patricia's criminal case moved slowly through the system. She pleaded not guilty and hired a criminal defense attorney. In the meantime, the HOA board held an emergency meeting and voted to suspend Patricia from her position pending the outcome of the criminal case. Marcus Chen became interim president. Marcus called me personally to apologize. "I want you to know that the board never authorized or approved any of Patricia's actions after the court decision. What she did was completely on her own, and it was wrong. The HOA is dropping all previous complaints against your property, and we're reviewing our regulations to ensure this kind of overreach doesn't happen again." "I appreciate that, Marcus." We'd also like to reimburse you for your security camera system and any other expenses related to the vandalism. That would be fair. The HOA sent me a check for $5,000, covering the cameras, the time I spent restacking wood, and the stress of dealing with the entire situation. It felt like a reasonable gesture. Patricia's preliminary hearing happened in April. I attended, sitting in the back of the courtroom. Patricia looked diminished somehow, less imperious than she had during the HOA meetings and the civil case. Her attorney argued that the evidence was circumstantial, that buying bleach wasn't a crime, and that cell phone tower data wasn't precise enough to prove her location. The prosecutor, a sharp woman named Jennifer Shaw, methodically presented the evidence. The phone records placing Patricia's phone near my property at the time of the incident, the security footage showing someone matching her general build, the purchase of bleach hours before the incident, Susan Fletcher's testimony about Patricia's threatening statements, my previous documentation of harassment, and the threatening letter. The judge found probable cause to proceed to trial and maintained Patricia's bail conditions, which included a no-contact order preventing her from coming near me or my property. As we left the courthouse, Patricia's attorney approached David. My client is interested in discussing a plea agreement. The plea negotiations took several weeks. Patricia's attorney wanted minimal charges, just a misdemeanor with probation. Jennifer Shaw, the prosecutor, wanted jail time. They eventually reached a middle ground. In June 2024, Patricia Pemberton pleaded guilty to 1 count of criminal mischief, a misdemeanor, and 1 count of reckless endangerment, also a misdemeanor. The sentencing hearing was scheduled for August. At the sentencing, I was allowed to make a victim impact statement. I stood at the podium, looking at Patricia, who sat at the defense table with her eyes downcast. Patricia Pemberton's actions weren't just about me or my outdoor boiler, I said. They were about power and control. When she couldn't get what she wanted through the legal system, when a judge ruled against her, she decided to take matters into her own hands. She snuck onto my property in the middle of the night and tried to damage equipment that I depend on to heat my home in Vermont winters. That's not just vandalism. That's an attack on my safety and my ability to live in my own home. I'm grateful that my security cameras caught her in the act, but I'm disturbed that someone in a position of community leadership thought this was acceptable behavior. The judge, a different one from the civil case, listened carefully. He then addressed Patricia directly. Mrs. Pemberton, you held a position of trust in your community. Instead of accepting a lawful court decision with which you disagreed, you chose to engage in criminal behavior. You could have caused serious harm to Mr. Xander. This court takes such abuse of authority seriously. He sentenced Patricia to 90 days in county jail, suspended to 30 days actual incarceration, followed by 2 years of probation. She was also ordered to pay restitution for all damages, including my legal fees from the criminal case, my security system, and compensation for my time and stress. The total came to nearly $30,000. Additionally, the judge issued a permanent restraining order preventing Patricia from contacting me or coming within 500 feet of my property. He also ordered her to resign from any HOA positions and prohibited her from serving on any HOA board for 5 years. Patricia served her 30 days in the Chittenden County Correctional Facility. During that time, the Pine Ridge HOA underwent significant changes. The board rewrote their regulations, adding provisions to protect grandfathered equipment and structures. They also implemented checks and balances to prevent any single board member from wielding unchecked authority. Marcus Chen proved to be a reasonable and fair HOA president. Under his leadership, the association focused on actual community improvements, organizing neighborhood cleanups, coordinating snow removal, and maintaining common areas. The adversarial relationship that Patricia had fostered gave way to a more collaborative approach. Several months after Patricia's release from jail, I received a letter from her attorney. Inside was a handwritten note from Patricia herself. It was brief and to the point. "Mr. Xander, I owe you an apology. My behavior was inexcusable. I let my pride and my desire to control things override my judgment and my ethics. I'm sorry for the stress and danger I put you through. I'm working with a therapist to address my issues, and I hope that someday you can forgive me. Patricia Pemberton." I showed the letter to David, who raised his eyebrows. Interesting. Her attorney probably advised her to write this for her probation, but it seems relatively sincere. Do I need to respond? That's entirely up to you. I thought about it for a few days. Eventually, I wrote back a brief note acknowledging her apology and saying that I hope she found peace and learned from the experience. I didn't say I forgave her, because I wasn't sure I did, but I was willing to let the matter rest. Life returned to something resembling normal. My outdoor boiler continued to heat my house efficiently through the brutal Vermont winters. I expanded my security camera system and added motion-activated lights around my property. Not because I expected more trouble, but because the experience had taught me the value of being prepared. Tom Richardson and I became good friends. We'd share a beer occasionally, and he'd tell me stories about the old days in Pine Ridge before the developments and the HOA. "You did us all a favor," Tom said one evening as we sat on my porch watching the sun set over the mountains. Patricia needed to be stopped. She was turning this place into some kind of dictatorship. I just wanted to keep my heat source. That's how these things start, though. One person stands up for what's right, and it makes it easier for others to do the same. In the fall of 2024, I ran into Linda Thompson, Gerald's daughter, at a farmer's market in Burlington. She gave me a hug and thanked me for protecting her father's legacy. "Dad always said that boiler was the best investment he ever made," she said. "He'd be proud that you fought to keep it." The legal aftermath continued in smaller ways. The HOA's insurance company paid most of my restitution, though Patricia was responsible for paying back the insurance company. David told me this would likely follow her for years, impacting her credit and her ability to get insurance herself. The civil case set a precedent in Vermont for similar HOA disputes. David told me that he had been contacted by other attorneys representing homeowners in HOA conflicts, asking for copies of our briefs and the judge's decision. Our case was cited in at least 3 subsequent cases, all decided in favor of homeowners with grandfathered equipment or structures. In early 2025, the Vermont state legislature even introduced a bill to clarify and strengthen protections for grandfathered property uses, explicitly limiting HOA authority to impose retroactive restrictions. The bill's sponsors cited my case as an example of why such legislation was necessary. The bill passed both chambers and was signed into law by the governor in March 2025. I was invited to attend the bill's signing ceremony at the State House in Montpelier. It was surreal standing there, watching the governor sign legislation that had been inspired by my fight to keep my outdoor boiler. A reporter asked me how it felt. "I just wanted to heat my house," I said. "I never expected it to become a legal battle or a state law, but I'm glad something positive came out of it. Property rights matter. The right to use your land in ways that don't harm others, that's fundamental. HOAs have their place, but they shouldn't have unlimited power to override those rights." The governor, a practical woman who had grown up on a Vermont farm herself, nodded in agreement. Too many homeowners associations have lost sight of their purpose. They're supposed to maintain property values and resolve common issues, not dictate every aspect of how people live. This law restores some balance. Back in Pine Ridge, life settled into a comfortable rhythm. The HOA under Marcus's leadership became something I barely thought about. They sent newsletters about upcoming community events, and occasionally there were votes on common area improvements, but the adversarial relationship was gone. I continued cutting and splitting wood each fall, filling my wood shed and preparing for winter. The outdoor boiler hummed along reliably, just as it had for nearly 40 years. On cold January mornings, when the temperature dropped below zero and ice formed intricate patterns on my windows, I'd go out to load wood into the boiler and feel a sense of satisfaction. This was my home, my land, my choice. Patricia Pemberton sold her house in Pine Ridge and moved away in late 2025. I heard through the neighborhood grapevine that she had taken a job in retail management somewhere in New Hampshire. I hoped she had learned from the experience, but mostly I was just relieved that chapter was closed. My security cameras, installed out of necessity during the conflict, proved useful in unexpected ways. They captured beautiful wildlife footage, deer and foxes, and once even a moose wandering through my property. I started sharing some of the videos online, and they became surprisingly popular. Susan Fletcher remained on the HOA board and became a vocal advocate for homeowner rights within the organization. She apologized to me several times for not speaking up sooner about Patricia's behavior. I was scared, she admitted. Patricia could be so intimidating. I'm sorry I didn't find the courage earlier. You found it when it mattered, I told her. That took guts. The financial compensation from the HOA and the restitution ordered by the court more than covered my expenses. I used some of the money to upgrade my boiler system, adding better insulation and improved controls that made it even more efficient. I also donated to a legal aid fund that helped homeowners fight unfair HOA actions. If my experience could help others defend their rights, that seemed like money well spent. David Morrison and I stayed in touch. He handled some routine legal work for me, and we'd occasionally meet for lunch to catch up. He told me the case had brought him several new clients, other homeowners dealing with HOA disputes. You started something, David said over sandwiches one afternoon. People are standing up to unreasonable HOA demands more often now. They've seen that it's possible to win. I just got lucky. I had documentation, and Vermont has good laws protecting property rights. It wasn't luck. It was you being thorough and standing your ground. A lot of people would have given in, would have decided it was easier to just comply even when the demands were unjust. You fought back, and you won. Reflecting on everything that happened, from that first threatening letter to Patricia's arrest to the new state law, I realized how much had changed. When I first received the HOA's demand, I had been angry but also uncertain. Could they really make me remove my heating system? Did they have that much power? Learning the law, understanding my rights, and being willing to fight for them had made all the difference. The grandfathering provision in Vermont law was clear, but it would have meant nothing if I hadn't been willing to invoke it and defend it. The experience also taught me about documentation. Everything I had kept, every receipt, every permit, every maintenance record had been crucial in proving my case. Gerald Thompson's meticulous record-keeping from decades past had saved me. I made sure to maintain that same level of detail going forward. My outdoor boiler, that beast of metal and fire that had sparked such controversy, continued its reliable work. Each cord of wood I fed into it represented independence and self-sufficiency. In a world where more and more aspects of life were controlled by regulations, permits, and associations, being able to heat my home with wood I had cut myself felt like a small but important freedom. I thought sometimes about Patricia Pemberton, wondering if she understood why what she had done was so wrong. It wasn't just the vandalism, though that was serious enough. It was the fundamental betrayal of her position. She had been entrusted with authority to serve the community, and she had used that authority to pursue a personal vendetta. That kind of corruption, even on a small scale, eroded the trust that communities needed to function. The restraining order preventing Patricia from coming near my property remained in effect. I never saw her again after the sentencing hearing, and I was fine with that. Some things were better left in the past. By the spring of 2025, when the snow finally melted and the trees began to bud, I stood on my porch looking out at my property and felt a deep sense of contentment. The outdoor boiler sat in its usual place, surrounded by neatly stacked wood. My security cameras kept watch. The mountains rose in the distance, still snow-capped. This was home. This was worth fighting for, and I had won not just a legal case but something more important, the right to live on my own land in the way I chose as long as I wasn't harming others. That was the promise of property ownership, and it was a promise that Patricia Pemberton and the HOA had tried to break. But the law had been on my side, and justice, slow and expensive though it had been, had prevailed. My outdoor boiler, grandfathered in and legally protected, would continue heating my home for years to come. And if anyone else ever tried to demand I remove it, well, I had a file cabinet full of documentation and a very good attorney's phone number. The whole experience, as stressful and expensive as it had been, ended up strengthening my connection to my property and my community. Tom Richardson and I weren't just neighbors anymore. We were friends who had weathered a storm together. The reformed HOA under Marcus Chen actually added value, organizing things that genuinely helped the community without overreaching into individual property rights. Even the security camera system, installed as a defensive measure, had become something I valued. It gave me peace of mind and captured moments of beauty I would have otherwise missed. As I loaded wood into the boiler on a chilly spring morning, I thought about how a simple piece of equipment had become the center of such drama. But it was never really about the boiler itself. It was about power, control, rights, and the rule of law. Patricia had thought she could impose her will regardless of what the law said. The courts had proven her wrong. The criminal justice system had held her accountable, and the legislature had strengthened protections to prevent similar abuses. My outdoor boiler, installed in 1987 by Gerald Thompson, and now operated by me, stood as a testament to the enduring principle that property rights matter, that laws protect citizens from arbitrary authority, and that sometimes standing up for what's right, even when it's difficult and expensive, is the only choice worth making. The fire inside the boiler crackled as I closed the door, radiating heat that would warm my home throughout the day. It was the same heat that had warmed Gerald's home for decades, and with any luck, it would continue long into the future. Not because I was stubborn, though maybe I was, but because it was my right, protected by law and defended in court. Patricia Pemberton had learned the hard way that rights backed by law aren't mere suggestions. The HOA had learned that their authority had limits. And I had learned that documentation, perseverance, and good legal counsel could overcome even the most determined opponent. My outdoor boiler hummed contentedly in the spring air, grandfathered in, legally protected, and here to stay.